Ladies and gentlemen, thank you for the honor of addressing this conference. I'm humbled by this opportunity to offer remarks on the soil and in the midst, the history and tradition of so many who have gone before us as great defenders of the faith and ardent supporters of religious freedom. Sincere thanks to the Laboratory of Religious Freedom and the Faculty of Theology of the Nicholas Copernicus University here in Toruń for extending to me this invitation to be with you. It is certainly a highlight of 2021. And special thanks to you, Professor Vaney, for the invitation, for the collaboration over the past 2 years. As you know, I come from the Religious Freedom Institute in Washington, D.C. Our office sits in the shadow of the U.S. Supreme Court as the sun sets across our nation's capital. Our mission at RFI is to promote broad acceptance of religious liberty as a fundamental human right, a source of individual and social flourishing, the cornerstone of a successful society, and as a driver of national and international security both at home and abroad. We work with a consortium of partners in the U.S. and abroad to advance policies to help those who are persecuted for their faith, defend rights of conscience, advance the free exercise of religion, and train today's youth to understand the critical role that religion and religious freedom plays in society. We share the laboratory's goal of preventing crimes against freedom of conscience and religion and any discrimination against religious affiliation. We hope, our good Lord willing, that our time today and our collaboration that began 2 years ago will continue to mark the beginning of a partnership to protect and advance religious freedom through education. Our time is limited today, so let me press forward. You will note the title of my address, Erosion of Orthodoxy, Cultural Threats to Religious Freedom in Law, Politics, and Culture. The primary title again, Erosion of Orthodoxy. Certainly, I might have further defined the title as the erosion of moral orthodoxy. For basic traditional views about life, abortion, the sacred bond between man and woman in marriage, and God's very creation of male and female are under assault. And much of what I have to say today will apply to that context. But I am convinced that the issues of our day, while including these fundamental elements of moral orthodoxy, may be rooted in something even more basic. What we see today is a struggle to define reality. And in essence, a conflict between two competing accounts of reality. A reality in which God is relevant and religious truth, or orthodoxy, as I mean it, shapes our understanding of reality, over against a reality in which God is not relevant or no longer relevant. Religious truth is antiquated or meaningless, and the dogma of self shapes an understanding of reality. It is a reality so unlike Rembrandt's in his painting of the crucifixion when he placed himself among the mockers. In the latter version of reality, it is not a transcendent, but really a supra-individualism that shapes reality. I do not refer here to a slightly exalted sense of self, or even a radical individualism that may have grown out of secularism. But what I refer to is a supra-individualism, a sort of self-apotheosis in which the individual shudders regard for his creator and may take it upon himself or herself to define the limits of the womb, the roles of marriage and family in society, and the very nature of human beings. This is the path of culture today, whether you live in Washington, D.C., or throughout Europe, or other places on the globe. And it is playing out on the world stage, in our courts, in politics, in our institutions of faith, and in our schools. Let us turn briefly first to the courts, particularly the U.S. High Court. Time does not allow us to visit other tribunals, so let me talk a little bit more about what I know. The end of summer 2020 brought with it the close of an unprecedented term for the U.S. Supreme Court. This was certainly true in relation to cases decided on the basis of First Amendment protections and other cases impacting fundamental principles of religious freedom. Over a 24-day period, from June 15th to July 8th, 4 U.S. Supreme Court decisions were handed down that will likely impact the free exercise of religion in America for years to come. I don't recall a Supreme Court term in my lifetime in which there has been such a flurry of issues come before the High Court involving religious freedom. And certainly not a single summer with as many watershed cases decided. Take a short journey with me in American jurisprudence. For over the first 100 years following the founding of America, there were no cases decided by the U.S. Supreme Court concerning the Establishment Clause or the Free Exercise Clause of the First Amendment. Following Reynolds v. United States in 1879, which most consider the first landmark Supreme Court case concerning the Free Exercise Clause, it wasn't until the 1940s that other landmark religious freedom cases were decided by the Supreme Court. As we get into the 60s and the 70s, we start to see more challenges to religious freedom taken up by the High Court. In 63, the landmark decision in Sherbert v. Verner. In 72, Wisconsin v. Yoder. In the 80s, as many as 8 landmark decisions involving such issues as the display of the Ten Commandments, prayer before the opening of the state legislature, the presence of a nativity scene in a public park at Christmas, and other basic issues. Another 7 or more in the 90s, and approximately 11 in the first decade of the new millennium. But never before, to my knowledge, have we seen such a flurry of cases and flurry of Supreme Court decisions implicating the free exercise of religion for individuals and institutions in a single term. Why now? What underlies this trend? And what does it say about the cultural threats to religious freedom in law and culture? And so quickly we consider these 4 cases from the summer of 2020. As these cases involve the First Amendment to the U.S. Constitution, let us remind ourselves of the 2 religion clauses to which I refer. And I quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Let me remind you that with those words, the framers of our Constitution established religious freedom as the linchpin in America's democracy that would strengthen other inalienable freedoms and contribute to a host of social goods that would cause America to flourish. Now the cases. Walk through me just briefly with these cases. It's challenging, it's sometimes boring in law school to look at cases. I know that. So bear with me. The treatment will be short, but let's catch the heart and meaning of these cases. First, Espinoza versus Montana Department of Revenue, decided on June 30th of 2020. The first case we consider sheds a ray of hope as you look at an otherwise cloudy landscape. It is a case about a form of religious discrimination that has been prevalent in the U.S. since the late 1800s. The case is about Montana's Blaine Amendment, a law similar to what is found in nearly 40 states around America that bans sectarian or religious schools from receiving public funding. Ratified first in Montana in 1889 and was ratified again, surprisingly, even in 1972. Strong anti-Catholic sentiment, which was prevalent across the U.S. in the late 19th century, is what led to the ratification of these laws. In Espinoza, the High Court ruled that the Montana Supreme Court violated the Free Exercise Clause of the First Amendment when it applied a state constitutional no-aid provision to bar religious schools from receiving scholarship money under a state tax credit program. The result? A family receiving a scholarship under the program may use it at any school, religious or otherwise, that meets all statutory criteria to function as a qualified education provider. This was a long-awaited win for what we would call free exercise equality. 100 years in American history to defeat this deeply entrenched discriminatory law against Catholic schools. It is maintained that law shapes culture. At least if you're in a room of lawyers, that's what the lawyers will tell you. Lawyers at least like to maintain that, and to be sure, good laws are intended to bring order to society and shape how citizens live in community with one another. But the next three cases are clear indicators of the impact of culture upon law. We consider Our Lady of Guadalupe School versus Morrissey Berry, decided on June 8th, 2020, and also Little Sisters of the Poor, Saints Peter and Paul Home versus Pennsylvania, decided also on July 8th. I treat these cases together because the court's decision in both cases came down, yes, on the same day, but more significantly because both cases are decided on the basis of a special exception supporting religious freedom. In the first, Our Lady of Guadalupe School versus Morrissey Berry, which was consolidated with another case, St. James School versus Beale, the cases involved employment discrimination suits filed by teachers at two Catholic schools in the city of Los Angeles. In Our Lady of Guadalupe, a teacher was terminated because she failed to integrate a new advanced reading program into her classroom instruction. She filed a lawsuit in federal court claiming she was fired on the basis of her age. She had taught many years, she was indeed elderly, and she claimed federal discrimination based on age, which would have been illegal under the Age Discrimination in Employment Act of 1967. In the consolidated case, St. James School, the school chose not to renew a teacher's contract based on observations that she could not maintain control over her classes. The teacher, who had been ill for some time, claimed that she was terminated in violation of the American with Disabilities Act. In reviewing both of these cases and reaching a 7-2 decision in favor of the Catholic schools, the court hearkened back to its application of what's called the ministerial exception, back to the Hosanna Tabor case decided in 2012. There, writing the majority opinion in that case, Chief Justice John Roberts stated, and I quote, "Requiring a church to accept or retain an unwanted minister or punishing a church for failing to do so intrudes upon more than a mere employment decision. Such action interferes with the internal governance of the church, depriving the church of control over the selection of those who will personify its beliefs. Like here, in Our Lady of Guadalupe and St. James School, the plaintiff in Hosanna Tabor was a teacher at a parochial school. Under the reasoning of the court, in each instance, in that case and the two we consider today, the teachers were considered ministers because they exercised important leadership roles in the school. They were charged with imparting the faith to their students, as many of you are. And under a special exception grounded in the religion clauses of the First Amendment, known as the ministerial exception, the court saw no place for the federal government to interfere. According to Justice Alito, who wrote the majority decision, when a faith-based school entrusts a teacher with the task of educating students in matters of faith, judicial review of the employment practices of the school undermines the school's independence in a way that the First Amendment does not permit. And so the court ruled in favor of the Catholic schools, 7-2. Now, for the purposes of this address, and really lest I lose my train of thought, let me make 4 observations about the ruling in Our Lady of Guadalupe School. First, we celebrate the High Court's decision, but we do so with caution. You might ask, why? Well, of course, we are encouraged the Supreme Court has reaffirmed that faith-based educational institutions in America are independent of government interference when they decide who effectively educates their students in matters of faith. But the opinion stopped short, applying the ministerial exception to all positions at a religious school when it stated, a teacher such as an instructor in a class of world religions, who merely provides a description of the beliefs and practices of a religion without making any effort to inculcate those beliefs, could not qualify for the exception. And so we pause. The weakness of the ruling is self-evident. It leaves open the possibility, perhaps even invites, cases in which the Supreme Court may choose to limit the ministerial exception by applying it only to those employees who impart formal religious teaching. But for many faith-based institutions, every employee is important to their mission. Every employee is trusted with representing the core values of the institution and representing the religious principles that animate the institution. Employment decisions made by religious institutions are not inviolable, but we need to be clear that America's founders did not rest America's first freedom on the tenuous nature of this exemption or any other. This decision reminds us that when we begin to understand religious freedom as one or a cluster of special exceptions, we are moving away from what the founders envisioned. We are misunderstanding the central and extraordinary role of religious freedom in society as intended by America's founders. We now move to our second case decided on July 8th, Little Sisters of the Poor versus Pennsylvania, which brought to a temporary conclusion legal battles for the Catholic Women's Religious Order. Many of you may know this case. It's been in the news for 10 years. The Little Sisters have to be tired. The Little Sisters had been in a battle first with the federal and then state courts since 2011, when the order first refused to comply with a mandate prescribed by the Obama-era Affordable Care Act. Provisions of the act forced many faith-based institutions to offer contraception in their health care plans. The Little Sisters simply could not do it and refused to do it because the practice would force them to violate their faith. In a 7-2 decision, again, with Justice Clarence Thomas writing the majority decision, the court upheld the exemption. Note again, religious freedom defined by an exemption. The exemption was granted by a presidential executive order in 2017, affirming that the Little Sisters are protected from undue interference from the federal government. Despite the favorable ruling, 4 of the justices agreed that a forthcoming challenge in the lower courts over a technical matter may drag the sisters back into court again. I must ask myself and our leaders, is this what our founders intended when they penned the First Amendment to our Constitution? Should not the deep faith of these honored and faithful servants be protected by the broad stroke of the pen that drafted our First Amendment, rather than holding out for the hope of an exemption? I made these arguments before a group of lawyers on the campus of Notre Dame University. And of course, lawyers tend to think about arguing in courts, finding those exceptions. And this indeed is a worthy battle. It is one we must undertake. But I noticed my colleagues, as I spoke, with glossy eyes, wondering, what is he talking about? Why is he saying? We find value in these arguments. We, in fact, find a landscape on which we can support religious freedom in these exemptions, but it is not a picture of religious freedom as our founders penned it in the Constitution. Our final case, and you're saying, David, I feel like I'm back in law school if you're a lawyer. Our final case, decided June 15th of the same summer, actually prior to the 3 that we just covered, is the one that really stirred the pot. 2 to 3 weeks prior to the 3 aforementioned cases, Bostock versus Clayton County redefined the term sex, weakened women's and girls' rights and protections under the law, and aligned with trends of culture rather than historical statutory precedent. In a shift of seismic proportions, the court ruled in a 6-3 decision that federal law prohibiting employment discrimination based on sex makes it unlawful for an employer to fire or refuse to hire an individual for being gay or transgender. Title VII of the U.S. 1964 Civil Rights Act states this in Section 703, and I quote, "It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." For over 5 decades, the term sex in this historical civil rights statute has meant biological sex, male and female as created by God. Courts at every level, even the lower courts, have understood the term in that manner. But here, claiming to be loyal to the literal meaning of the text, Justice Gorsuch so typically an ardent defender of religious freedom. Here, writing for the majority, he deviates entirely from a textualist approach. Despite admitting that the law's drafters in 1964 intended the term to refer only to biological sex, he now finds within today's cultural milieu that homosexuality and transgenderism are bound up within the meaning of the term. Justice Alito, I think, was justified in his critique. And he said, I quote, "There is only one word for what the High Court has done today: legislation." It is not understanding the original meaning of the law in its historical context and applying that understanding to a current set of facts based on legal precedent. It is the making of law. Now, I admit, I am beyond baffled by the ruling. Trained in the study of languages, I readily admit I'm a textualist. Spending years in the study of Greek and Hebrew and other languages for the purpose of academic research, I was taught to pay attention to every accent mark, every breathing mark, to pay careful attention to the antecedents, to syntax, and the plain meaning of words in their historical context, and I required no less of my students. The favorite course I ever took was a year-long course, meeting 4 days a week, syntactically diagramming the book of Romans. You say, David, you're a different breed. Probably true. But I admit I'm a textualist, so when I come to the text of the Constitution, I approach it this way. Or to a federal statute, I approach it this way. But apparently I'm not alone. For Justice Alito wrote in his dissent, without strong evidence to the contrary, and there is none here, our job is to ascertain the ordinary meaning of the statute. The implications of Bostock are far-reaching. Immediately, within the next couple of weeks, the Equality Act was reintroduced into Congress, into the Senate. It had passed the House. Within a month, the Equality Act, and I'm sure many of you have heard about the Equality Act, H.R. 5, was scheduled for a hearing by the Senate Judiciary Committee and was brought before that committee in the form of a hearing. It has not been brought to the floor for a vote in the Senate, but it is, I would say today, the most serious threat on American soil and in American jurisprudence to religious freedom. Let me draw a few things to a conclusion here. We've spent a lot of time looking at the law. And as I said, lawyers like to say that law forms culture. But in fact, when you look at my title of this address, Cultural Threats to Religious Freedom in Law, Politics, and Education, in the first two, culture is shaping law. That's certainly true in the United States, and I venture to say it's true here and throughout Europe. It is today culture that is shaping law, and I don't doubt that in that decision in Bostock, the cultural influences of our day were shaping that decision of even our highest court. So what do we do? Let me fast forward and answer that question. What does this mean? How do we appropriately respond in the face of sexual orientation and gender identity ideology, which shaped the decision in Bostock and which is leading to the promulgation of the Equality Act in our courts in the United States? First, rediscover kindness. This is not conversation in culture to have an anger or an animus. Our faith would teach us to rediscover kindness, to discuss our differences today in culture and society around the table. That would be my first word of response. But second, recognize that the decision in Bostock and the Equality Act is a direct affront to religious orthodoxy and a direct threat to religious free exercise. It exposes faith-based institutions to ruinous lawsuits. It threatens women's rights and safety. It may mandate the performance of medical procedures and the provision of medical products contrary to one's faith. It redefines faith-based institutions, the Equality Act does, as places of public accommodation, creates unsafe environments for our children, and abolishes the Religious Freedom Restoration Act and the high standard of strict scrutiny as a defense to sexual orientation and gender claims brought under the Equality Act. Third, and I'm hastening to a close, understand that the Equality Act and this ideology and what it teaches about men and women is built on false views of human nature and human sexuality. It bypasses humanus dignitate and human dignity and what it means to be human and created in the image of God. Understand that sexual orientation, fourth, and gender identity ideology represses religion and drives religious freedom from public life. Yes, sit at the table. Find kindness to have these conversations, but speak the truth. Fifth, restore the highest standard of judicial review, known as strict scrutiny, to resolve challenges to religious freedom and other constitutional rights. Be happy to talk further about that with you. And then sixth and last, make God relevant through education. If we're talking about two competing versions of reality, one in which religious orthodoxy and an understanding of the transcendent is in the shadows, then let's bring that teaching back fundamentally into our schools, into our training programs for tomorrow's leaders. One of the oldest faith-based universities in the U.S. does not have a single student enrolled as a major in the School of Theology. I learned that this summer, and I have yet to grasp the reality of that. Each case we discussed today and the historical and legislative landscape we reviewed point to the fact that law and politics are both downstream from culture. Education is not. Some point out correctly that education is upstream from culture, and that is true. It stands in a unique place in society to help reshape culture and correct, dismiss, or promulgate harmful ideologies. But education is more than just an institution that stands upstream from culture. Education, my friend, is the incubator of culture. Certainly there are other influences on culture. The media, of course, your peers, the other institutions, but education is the primary incubator of culture. Through intentional and creative teaching in the classroom across all levels, we can restore religion and religious freedom to its proper place in culture and law. My last page is blank. That means I'm finished. Thank you very much.
Thank you very much, David. I have taken so many notes, that, but I think that now is the perfect time for questions. And I mean, then we will come back to many other things. And well, I would like to ask you to say your name and affiliation before the question. And the microphone will be given for you. So just let me know who would like to begin with the questions. Please, Fernando. Yeah.
Well, first, thank you very much, David, for your lecture, for your wonderful address. And well, my question has to do with more with the future than with the current challenges to religious freedom. Well, there is a case pending in the Supreme Court. We know very well the Dobbs versus Hobson, the Texas case of an abortion. And could you give us your impression of what is going to happen with that case? Maybe, I mean, you're not a wizard, but I guess that maybe you can give us a...
Thank you, Professor Yarza, for the question. You know, there were cases even after the summer of 2020, the Fulton case versus Philadelphia. And of course, we celebrate that victory as well for religious freedom, but we do so again with pause. But there was a sense in that case in which I was jubilant about the decision. When do you ever see a 9-0 decision in the U.S. Supreme Court? And one that actually showed respect for the longevity of the foster care services of the Catholic Foster Care Center there. 50 years they'd done this work, and they upheld a standard of respecting and honoring the sacred bond of marriage between man and woman. The court showed deference to that in their reasoning. I almost had to scratch my head and say, you know, is it possible to have a 9-0 decision? And this was after the summer of 2020. So I mentioned that case only because as I look into the crystal ball for Dodd, I have hope. I am optimistic about the direction that the court is moving. I'm unsettled, as you can see, about defining religious freedom continually in the form of exemptions. These are victories. These are decisions that are based on judicial mechanisms that respect and protect religious freedom. But I think they miss the central and important place that religious freedom had in the minds of our founders. But in the court, I see hope. There is optimism. So it's very difficult to say. I mean, if you look on the state level, of course, you find Texas, my hometown, my home state. And you see what's going on there with the abortion cases and the abortion laws and the attack. I don't know if we'll get there in Dodd, but I'm optimistic. And I think at least Dodd will be a step, perhaps, I hope, in a positive direction in dealing with this precious issue of life. So I'm sorry I can't be more specific, but I do see steps in the right direction. And I think Dodd hopefully will be one of those. I don't know how far that will go, of course.
Thank you.
Okay, yes, please.
Thank you. Tomasz Bednarek, Laboratory of Religious Freedom. Professor, I would like to ask you about your opinion about United States intellectuals, thinkers, who are often called integralists or neo-integralists. I think, for example, Adrian Vermeil, Patrick Dennin, Chuck Pecknold, and so on. I would like to ask you about your opinion about their views about state and church relations, and that they are very critical, negative towards originalism in American constitutionalism. I mean, for example, Beyond Originalism by Adrian Vermeil, and that they're critical towards fusionism, which was, I think, quite popular among Republican Party, among American conservatists in the last 50 years. Thank you.
You know, I wish the time was up. It's a very challenging question. I did not hide, well, nor did I intend to, the fact that I'm more of an originalist, a textualist, very bound by the context of the Constitution and the words of the Constitution in relationship to one another at the time in which they were written. In that sense, it takes a lot for me to ever deviate from that course of understanding and interpretation. In no way am I trying to avoid your question, so let me say that. This is a heated debate in American jurisprudence, in politics, and on our academic campuses. And let me say it is one that I am still interacting with. I find great challenges from the integralist approach, and am working through those, I think, intellectually. But I have found nothing to pull me away from more of the originalist approach in which I was trained and find identity most. So let me say I would enjoy the conversation with you as I continue to work out that debate, which is really, really a huge debate, not just here, thank you for raising it, but across campuses in the U.S.
Well, I don't know if there's another question. Okay. Okay. So please. I also have a question, but I will wait. And eventually I will ask you outside when we finish. Please.
Adam Jakuszewicz, Kazimierz Wielki University in Bydgoszcz, Department of Law and Economy. Professor, I'm a textualist too, so we are both textualists. And I would like to ask you about Strasbourg tendency in jurisprudence. I don't know whether you're familiar with it, but European Court of Human Rights argues that religious sentiments or religious feelings are protected through freedom of religion or on the basis of freedom of religion. But if you read the text of the convention, well, there is a right of freedom of religion, and there is no right to have one's feelings protected. And there is no right to profess one's religion in a friendly atmosphere. There is no human right to feel nice. And the Laboratory of Religious Freedom and other organization presents cases of vandalism or hostile behavior towards religious people as instances of the breach of religious freedom. How would you comment it? And the other question would be about the cluster. You are arguing that religious freedom becomes a cluster of exemptions. And you invoke founders of American Constitution, but don't you think that we live, unfortunately, we live in a secular world, and this tendency that the freedom of religion will become a cluster of exemptions is inevitable, unavoidable, because we live in a different world than the founders of the United States. Okay, thank you very much.
I think questions. I'm not sure, but let me make a couple of comments that at least touch upon your comments. Not everything that at times gets classified as religion is religion. We say at the Religious Freedom Institute that religious freedom is important because religion is important. And if we don't understand what religion really is, then we cannot appropriately defend and promote religious freedom. And so we begin with a definition of religion. That religion is a basic and inalienable right to search for ultimate truth in a transcendent reality. And when finding that truth, the freedom to so order one's life accordingly. Both elements of that, I think, go to your first part A of your question. There are those who argue with me at times that secularism is a religion, that even sexual orientation and gender identity is a religion. Again, going back to our definition, religion is the freedom, the inalienable freedom to search for ultimate truth for everyone, for everywhere, to search for ultimate truth in a transcendent reality. Religion is not just a set of ideas. And in fact, it is a freedom to find truth or perhaps not to find it. But when finding it, then, to have that inalienable freedom to so order one's life, to practice it accordingly. I'm forgetting part B to the question, which is really where I wanted to go. Oh, this is important, yes. So, living in a society and a culture that continues to marginalize, compartmentalize religion, are we not simply on a path that inevitably takes us that direction? I hope that's not true. We have no time to see this here, but later on in part of this conference in which I'll be participating, we'll be looking at empirical evidence of the relationship, the correlation between religious freedom in society and common goods in society. We'll be looking at how in societies in which religious freedom is more warmly embraced and protected, there is more social justice, more equality for men and women, more economic prosperity, less poverty, more safety. We'll be looking at the correlation based on empirical evidence between those things. I hope that religious freedom does not continue to be marginalized or compartmentalized. It's not what our founders meant. It plays a critical role, a central role in securing other inalienable freedoms. When it becomes marginalized or siloed, those other inalienable freedoms are weakened, and the social goods in society are compromised. So I want to stay optimistic. I don't think we have to go that direction. I think we could, if we're not careful. But this is where we must come together and find ways, I think, to restore religious freedom to its proper place in society and culture.
Well, thank you very much. I think that you have you have given us many things to think about and to discuss. I was thinking about what you mentioned, that we used to think that law shapes culture, and that really what we are seeing right now is that culture is shaping law. And probably what you mentioned about the exceptions, I mean the protection of religion based on special exceptions, is because we are looking at the reality in terms of legal aspects. We are not looking into, I mean, religion as, and freedom also, freedom and religion as those realities that are really based on human nature, that are really based not in law. I mean, law gives a frame to, I mean, to protect that. But I think that, as you mentioned, we would need to reshape culture according to human nature, to look how to make God relevant. So, and this is a big challenge. But I mean, I'm also optimistic. I prefer to be. And I think that we have today and tomorrow, 2 days, to deepen this dialogue, which you also mentioned the importance of dialogue, and to try to find common ways to work together in order to develop this kind of optimism or these challenges in a positive way. I'm sure we will find many of them, and we will try to work together through them. So thank you everyone for being here. We have now a break, a coffee break.